afternoon. My name is Maria Chakla. I am a UPC representative based in Paris. And we welcome you and thank you for registering today. And I'm delighted to present you this webinar, which is based on our experience at the UPC, as well as our finding on the 18 months of existence of UPC. Our objective today is to provide you with some trends we have noticed. But as well, we have designed the webinar to be proactive. For that reason, you will have the possibility to take part in one of our breakout sessions, which will be moderated by some lawyers of our Gowling UPC task force, Céline Bay, Alex Brody, Mathilde Gramont, Alexis Augustin, Hugh Evans, Michael Carter, Seiko Hidaka, Alex Driver, and myself. So welcome, Céline. I'm giving you the floor to explain in greater detail the agenda of the webinar.
Thank you, Marianne. Hello, everyone. Thank you for joining us today. So as Marianne said, our webinar today is a little bit different from what you may be used to, as we wanted to make it as interactive as possible and to give you the chance to choose the topic that you want to hear about. So we gave you the possibility in advance of this webinar to share topics and to share questions that we wanted us to address. So in about 20-25 minutes, we will invite you to join one of our breakout rooms. The audience will be then divided into three smaller groups where you'll be able to hear and exchange, if you want, in an informal way on three topics. And the topics are the following. So in the first room, you'll be able to discuss injunctions at the UPC. So this topic includes, of course, preliminary injunctions, as we know that it is an important part of the strategy in a patent litigation. This session will be hosted by Alexis Augustin from our Paris office, UPC representative, Seiko Hidaka, who is Seiko, a UK patent lawyer from our London office, and myself. The second breakout room will discuss the obtention of evidence before the UPC. That will include, of course, the fearsome saisie contrefaçon. And this session will be led by Alex Brody, who is a patent litigator in our London office, Michael Carter, who is patent litigator in our Birmingham office, and Mathilde Gramont, who is a French patent lawyer and a UPC representative as well. And last but not least, in the third breakout room, we will have Marianne, as well as Hugh Evans and Alex Driver, both patent litigators in our London and Birmingham offices, and they will host a session focused on how to best get prepared as a defendant before the UPC. So you can already start thinking about which room you would like to join in about 20-25 minutes, when a pop-up will appear on your screen and you will be prompted to join a room. So you have to click on the button of your choice. I have to warn you that once you have chosen a room, you can't change and you can't go from a room to another. But we will make sure that the slides of the presentation of the different rooms will be made available to you after, because they will not be recorded. What will be recorded is the main webinar, so the presentation on the statistics and the Q&A, but not the breakout room session. And then once the breakout room session will be closed, we will all be back to the main webinar. And then if we have time, we hope, we will have a Q&A session. And if we don't have time, of course, you'll be able to raise any question to us in writing, and we'll be happy to answer all of those questions after the webinar. So I hope everybody will enjoy this session. And let's not wait too much before starting with trends and statistics. And I give back the floor to Marianne, and we will discuss after 18 months of operation, can we say that the UPC is a success?
Yes, Céline, actually, we can say in one sentence, that UPC is running an impulsive start. So we'll start with some statistics on the number of proceedings which have been filed with the UPC. So according to the UPC official report, the total number of proceedings ever filed is 635. We can say that this figure is a bit misleading, as the UPC counts every counterclaim for revocation in one patent as a case distinct from the infringement action. That is to say that if you have one infringement action in which 2 patents are asserted and you have 2 counterclaims, it counts for 3 proceedings. So now let's have a laser-guided look at the statistics. So we can see here that from the very beginning, we started very immediately with 14 actions in 1 month, which is quite impressive. And today, actually, we have 239 infringement actions which have been filed. We can say that there are 251 counterclaims for revocation which have been filed. And as I said, the difference between the number of infringement actions and the number of counterclaims for revocation comes from the fact that actually you have some infringement actions which have several patents asserted. It is as well interesting to underline that in 43% of the cases, no counterclaim for revocation was filed. How can we explain that rate, which is quite high? As a non-German lawyer, I would say I was very surprised. And I think that the really likely explanation is that most of the actions, as Celine will explain, were filed before German divisions by German lawyers who are not used to discuss the validity of the patents in their infringement actions in Germany, given their bifurcation system. But as you know, in Germany, when you file an infringement action before a tribunal, this tribunal will not look at the validity of the patent. The validity of the patent falls within the jurisdiction of the Bundespatenthöfe. Interestingly, before the local division in Paris, actually in 100% of the cases, a counterclaim for revocation was filed. While in Germany, the figure is only 40%. So for me, I do believe that some defendants have refrained from filing a complete defense. And I think that all here in this group, as non-German lawyers, we are surprised because in our cases, infringement cases, we each time file a counterclaim for revocation. So now we have 55 main revocation actions which were filed. And I would say that when we compare that figure, the 55 to the 239, to me, it's a high figure as well. And this can be as well explained by the fact that the cases were started by Germans again. And we have only 4 declarations of non-infringement which were filed. It's a very low number, but not that surprising. First of all, it's not a traditional defense, I would say, to file a DNI. And second, it can be explained as well, given the number of opt-out patents, opt-out in place, sorry. So then we have 52 preliminary injunctions which were filed, and there are currently 127 appeals which are pending. Celine will provide you with more detail on the outcome of these proceedings later. But in summary, the rapid and steady growth is a clear indication of the confidence in the UPC, and the number of actions continue to increase since the first decisions were issued. So now let's have a look at another indication of the confidence in the new system, is the patents itself. And I thought it was very interesting to have a look at the request for unitary effect. At the very beginning, in 2023, the European Patent Office received many requests for unitary effect in a total of 17%. And I remember you that actually the system enters into force only in June. So in 2023, 70% of the patents granted had a unitary effect. In 2024, we are near 25%, which is quite high, very high, because 1/4 of the patents today have a unitary effect within the UPO. What is interesting to note as well is that 60% of the unitary patents were requested by owners from the EPO zone and 40% from 5 countries in the order of proportion: Germany, France, Switzerland, Italy, and the UK. 15% from the US and 15% from Asia. And between the 15% in Asia, you have China, Japan, and Korea. Another figure which is interesting is that 35% of the unitary patents were requested by SMEs. And I was very surprised by this number because traditionally the SME used to have with their classic European patent a protection in 3 or 5 countries. And when it were 3 countries, it were France, Germany, and the UK, which is outside the unitary patent system. So now we see that with this new system, the SMEs have an access to a broader protection in terms of geography for the cost of 5 European patents, actually, because that's the average. Main industries interested in the unitary effect are the medical or life sciences patent, computer and technologies, and civil engineering. Now about the opt-out, we can see that actually the number of opt-outs was very important at the very beginning because we had 421,000 opt-outs in place, and most industry have filed their requested the opt-out of their entire patent portfolio without a real strategy. Since actually they entered into force, we have only 130 additional patents which have been opted out. But what I would like to say, because when we say 550, it's quite a lot. But if we think about the number of patents in force, we have roughly 1.6 patents in force in Europe. Okay, so 1.6 million means that in the end, only 66% of the patents, or no, sorry, that 66% of the patents have not been opted out, or put it that way, only 34% of the patents have been opted out, which is not that much. It's another indication of the conflict. And with respect to the withdrawal of opt-out, there are only 446, but which is very low, but the withdrawal were filed when the patentee wanted to enforce their patent, actually, because when you withdraw your opt-out, it's forever. You can't opt out again when you have withdrawn your opt-out. Celine, I will give you the floor to explain in more detail the outcome of the decision.
Okay, so let's have a look a little bit deeper at the current distribution of the cases and see if we can draw some conclusion from it. Just a reminder before starting on the way the court operates. So we have a central division and we have 13 local divisions. So the central division, the head, I would say, is in Paris, and we have 2 other seats, one in Milano and one in Munich. And the jurisdictions of the central division is all the action in revocation and the declaration for non-infringement as well. The competence of the central division is established and divided by, I would say, fields of industry. So there is no room here for forum shopping. Just as a reminder, Paris knows of the revocation action against patent covering physics and electricity, SPC mainly. The Milan divisions know about, I would say, mainly the pharma patent, and the Munich division has jurisdiction over mechanical engineering, lighting, and mainly chemistry. So there is no room, I would say, for forum shopping before this central division. What we can see immediately on this slide is that so far Paris is leading the way, I would say, on the number of revocation action before the central division, with 42 actions, And this is mainly due to the importance of revocation actions against patent in electricity. With regards to local divisions, what we can say immediately is that, yes, what we were the difference of the central division, local division, there is a little room for forum shopping, but we will see later that forum shopping is not really the main word for UPC. But the jurisdiction of this division is when you start an action for infringement, you will go before the place of infringement, or you will go before the seat of the defendant. So if you have infringement occurring in more than one member state, for sure you will have the choice to go before the German division, before the Paris one, before Milan, etc. Just a reminder that today the UPC covers 18 member states. So what we can see immediately on the slide is that so far most of the infringement action have been brought before the German local division, 78%, with 38% before the Munich division. So as Marianne said a moment ago, this is quite a big figure, but we don't think that this will stay the same in the future. What we can say here is that this is quite representative of the European patent landscape that we have been knowing so far. Because, for example, in 2023, there have been 500 decisions issued by the German court, so not UPC, but German national courts, compared to 100 in France and 40 in Italy. So it has always been that Germany has been the first place for patent litigation, but it could be explained maybe before the UPC opens, because Germany has a system of bifurcation. So you could obtain before German court a decision quite quickly compared to other jurisdictions, where in other jurisdiction the judge are in charge of validity as well as infringement at the same time. And it's true also that patent judges, German patent judges, are quite experienced judges, and this was a jurisdiction well appreciated for patent litigation. So we can see that for 1 year, the claimant replicated a little bit what we knew before for the European patents, but we think that that should not go on like this, and that there should be a kind of a rebalancing in the future for two main reasons. The first one is that, as you know, UPC is one single jurisdiction. It means that the same rules of procedure apply everywhere. We have the same, I would say, quality of judges, very experienced judges in patent in Paris, in Milan, and in Germany. We have technical judges as well everywhere. So we think that in terms of proceedings, in terms of proceedings and quality of the judges, there is no interest of going there rather than there. And the second reason important is the duration of the proceeding. And you can see on the slide that due to the workload of the German local division, they have started to have difficulties to issue decision in I would say a proper time frame. So what is a proper time frame? In the UPC rules, the court was set with the objective of issuing a decision on the merit on infringement within 12 months. So this is quite ambitious, but this is what really happened at the beginning. And we can see that 12 months is the duration average of the decision before the Paris division. But today in Germany, the last decision were issued after almost 18 months. So for sure, this is due to the workload. And we think that it will maybe be also a reason for the claimant maybe to go to a division with a lower workload, I would say, for this reason. A few words on the CESI on this slide as well. The CESI is a very powerful tool. It's a means of evidence, and we can see that the CESI have started to be granted by the UPC. We can see that it has started to be granted more before the Paris division than before other division. That is mainly because, and we think historically, the CESI is a means that we know in French patent law. It is known also to Benelux law and Italian law, but France is really has always been at the head of the CESI. And so this is why I think we see that there are maybe more CESI granted in France than elsewhere. And if this is a topic of interest to you, you'll be able to join the breakout room on evidence later that will address the CESI. A few other statistics to end. Marianne, maybe we can go to the next slide. Thank you. So a few other figures to go deeper into what Marianne said with regard to the decision. So far, 54 decisions were handed down by the Unified Patent Court, 25 preliminary injunction, 17 infringement decisions, and 7 decisions on revocation actions. The first teaching that we can see here is that if we can say that UPC is adopting quite a pro-patentee approach, this is also a very measured position because you can see on the percentage that most of the preliminary injunction application have been granted with 56%. So it's not a huge volume, but it's quite measured. It's comparable to what we see before national courts. And again, if you are interested in this topic, you can join later the breakout room on injunction. We can see from this slide that most infringement actions have succeeded with 59% of the action, so almost 60%. So this is why we can say after 1 year and a half that the UPC is quite patentee friendly. And finally, patents have been deemed valid as granted or valid in an amended form for 57%. So quite, as I said, a measured position from the UPC. The next slide is a focus on cost, and I will leave the floor to Marianne. You have been many to ask us about a comparison between national courts and UPC with regard to costs.
Thank you, Céline. So now the fees. Actually, as we say, the main advantage of the UPC is an access to a cost justice. And we are covering this topic about the cost to respond to a question we had received ahead of the webinar. I would say that as a general rule, we can anticipate that the cost for a UPC case should be relatively similar to the cost of a national court on the continent. I'm explaining the UK, sorry, my UK colleagues. But with the disclosure, we have a different system, so we can't compare. But given the timeline, what we should have in mind is that the expenses would be compressed within 13-15 months, because this is the length of the procedure before the UPC. And or as well, we have to keep in mind that if I say that it should be similar to what you know currently before the national court in New York, you will have to support additional costs for the determinations of the damages. Indeed, UPC proceedings are mainly divided in 2 stages. The first stage is going to be related to infringement and validity, Second step is going to be related to assessment of damage. And then you will have brief and hearing just to discuss on the damages. So that's my introduction. Then I would say that the main difference between the UPC and the national court system, except Germany, is that there are some court fees. You have fixed fees before the UPC. For instance, for an infringement, it will be 11,000 euros. If you file a counterclaim for a revocation, it's going to be the same price. And in infringement case, you will have to pay additional court fees, which are determined taking into account the value of the litigation. So it's from 0 up to 325,000 euros. So you have a very nice table which has been prepared by UPC you can refer to. So these court fees are quite similar to what exists in Germany. With respect to attorney fees, they are completely free, as is the case everywhere, except again in Germany, because in Germany, in addition to the court fees, you have the regulated attorney fees. But in addition to the regulated attorney fees, law firms are entitled to apply their free fees, actually to compensate the fact that the hourly rate of the fees before the German court is lower than their standard hourly rate. So that's the difference, which in the end has a consequence of the recovery of the legal cost. Before the UPC, that's going to be up to 2 million. In Germany, it's going to be the court fees plus the attorney fees, but only the regulated fees. While in France, Italy, and the UK, it's going to be at the court's discretion for Italy and France. And France, for instance, is going to be between 150K and 500 euros, sorry, per party. In the UK, you have a specific hearing on the cost. And in Netherlands, since the recent years, actually now the attorney fees, legal costs have been actually capped to 40K. So now that's what I wanted to say about the cost. You have now, it's our time for our breakout sessions.
Welcome to this breakout room session on injunctions. Thank you for joining us. I'm pleased to host this session together with my colleagues Seiko and Alexi. We've prepared a few slides on this topic, which is quite an important topic for our patent litigation strategy. Of course, this is the most important remedy that the patent owner seeks in an infringement action. We know that there are quite some differences between jurisdictions on the automatic or optional nature of permanent injunctions. So we'll start with this question and we start to see how it is like before the UPC. So before the UPC, I would say that the keywords, important keywords are balance of interests, flexibility, and enforceability when we speak about permanent injunction. First of all, let's see what are the conditions to obtain a permanent injunction. First of all, the court must find the patent valid, of course. The court must also find the patent infringed. And the third condition that is quite interesting is that the court will look at the balance of interest before granting the injunction. So that means that the injunction is not automatic, and we'll get back to this. Timing. The UPC agreement provides that decisions on the merits should be handed down within 12 months. So far, after 18 months of operation, we can see that today there is an average of 13 months to get from the start of the proceedings to the injunction. An average of 13 months, so that's quite close to the 12 months. We have discussed before that it also depends on the jurisdictions, and before the German local division, due to their workload. It's a little bit longer now, around 17, 18 months to get to the injunction. Targets. Injunction generally target the infringer, but as it is in other national European jurisdictions, before the UPC, you can also obtain a permanent injunction against any intermediaries. Enforcement, direct enforcement, that's important. Decision on the merits on infringement are generally directly enforceable from their date of service. So that means that if there is an appeal before the Court of Appeal, there is no suspensive effect. However, there are some rules and some possibility to obtain a suspension of the enforceability of the permanent injunction in case of decision that could be manifestly erroneous. And we have had recent decision from the Munich local division on 13 September 2024 in a Philips versus Belkin case, where the court ordered a permanent injunction against Belkin, but also against its directors, so natural person. The court considered that the directors could be qualified as intermediaries themselves. So Belkin filed an appeal and filed an application to obtain the suspension of this injunction against the directors. And the Court of Appeal granted the suspension, so pending their decision, because they considered that the interpretation made by the first instance court were manifestly erroneous, and that natural person in those type of circumstances could not be qualified as intermediaries. Let's have a look at two other notions we discussed before, optional and flexibility. As we said, the court must look at the balance of interest before granting an injunction. So that means that these injunctions are not automatic, and it's up to the court to decide. In practice today, so far, there have been 10 decisions on the merits, which have acknowledged validity of the patent and infringement. And in all those decisions, the permanent injunction was granted. So we do not have to date any decision, any example of where an injunction has not been granted on the basis of the balance of interest. So we will have to wait a little bit more to obtain or to see those type of decision and the rationale for the decision. Flexibility is also important before the UPC when we discuss injunction, and that's quite particular. We do not see that under French law and French case law, for example. We've seen so far some decision from the UPC where injunction was granted, but it was adapted to the circumstances of the case. For example, there was decision handed down in a case Edwards Life Science versus Merrill in November 2024. Local division Munich, and this case related to medical devices. And the local division in Munich decided that the injunction should not extend to the devices that had already been scheduled for implantation in patients. So the division really decided to grant the injunction, but to limit the consequences of this injunction in order not to prejudice the patient in this case. Next slide, please. Let's now have a look at the preliminary injunction. We know that this is a main tool in patent litigation strategy, preliminary injunction, because Sometimes when you've won your preliminary injunction, it's almost like you've won the case. It's very, very easy for sure or to settle afterwards when you won a preliminary injunction. On the contrary, it's also very risky, of course, to apply for a preliminary injunction, because if you lose, if the court refuses to grant the preliminary injunction, it will depend on the reason why. But of course, if the court has doubts on the validity of the patent, that's not a good sign for the case on the merit. What are the conditions to apply for a preliminary injunction? The patent must be valid prima facie. The patent must be infringed prima facie, and I think that Alexis will go back in a moment on these notions. The third condition that is very important before the UPC is urgency. And the fourth condition, as always, the court will take into account the balance of interests. When to apply for a preliminary injunction, like in many jurisdictions, before the UPC, the claimant can apply before the proceedings on the merits were commenced or during the proceeding on the merits. The purpose of preliminary injunction is to put an end to a prejudice that results from infringement and also to prevent the prejudice to start. So that means that you can apply, a claimant can apply for preliminary injunction when the infringement is only imminent and has not started yet. On this notion of imminence of infringement, the UPC has issued already some decision. And we can say that it is the position of the UPC is more or less the same as the position that we know in France, in the UK, or in Germany. Some example on the pharma sector. The Düsseldorf local division issued a decision in a Novartis versus Genentech case on 6 September 2024. And the division decided that having obtained a marketing authorization is not enough to prove imminent infringement. But applying for a price negotiation, a reimbursement, sample presented to clients, communication on the specific timeline for the launch to market, all of these can be considered as evidence of imminent infringement. So, as I said, we are here more or less aligned with what we know with national jurisdictions. A few words on timing. The average timing before the UPC to obtain a preliminary injunction is 3 months. But there is a big difference between the longer and the shorter procedure. The shorter procedure is 1 day. So it is good to know that if there is an urgency, a very important urgency, that a claimant can obtain a preliminary injunction very quickly. We have recent decision from the Milan local division dated 5 November 2024 in a Cardo system versus Shenzhen as Max case. The application for the PI was lodged the day before the opening of a trade fair, where infringing goods were supposed to be presented. And so the Milan division agreed to look at the application ex parte, so without the defendant being called to the proceedings, so without the defendant being able to file a defense. And the preliminary injunction was issued in 1 day, very quickly. So that's very good to know when you suspect imminent infringement on a trade fair. That's quite efficient. That's interesting as well to see that before the UPC, the court grants quite a lot of ex parte preliminary injunction, like the one we've just discussed. It's around 40% of the preliminary injunction that have been granted so far. So it's quite important. In France, for example, a claimant can obtain a preliminary injunction ex parte, but it is very uncommon. It is very rare that the court will not call the defendant to appear and to be able to file a defense before issuing the preliminary injunction. It can be done quite quickly in a few days in France as well, but it's very rare that it can be done ex parte before the UPC. As I said, it's not. It has become quite common. So this is something to keep in mind as well. A few last words on preliminary injunction and on the condition of urgency. I think that Alexis will discuss this a little bit deeper in a moment, but urgency is, so far, from what we can see from case law, the main condition on which the judges decide or not to grant preliminary injunction. We don't have so far decision that put into question the validity of the patent or infringement, but really the decision issued so far, the preliminary injunction issued so far, were based more on the notion of urgency. So that's a very important notion to keep in mind. So here is the picture for injunction before the UPC. What we're going to do now on the next slide, it's a kind of comparison between the UPC and national case law.
Thank you, Celine. So the purpose of this slide is, as Celine said, to present the condition for PIs to be granted before the UPC, as well as a brief comparison with the rules applying in some European countries. So as mentioned before, the first and second conditions for PIs to be granted are prima facie validity and infringement. Interestingly, Article 60, paragraph 4 of the UPCA provide that the courts may require the applicant for PIs to provide any reasonable evidence in order to satisfy itself with a sufficient degree of certainty that the patent is valid and infringed or about to be infringed. The first comment here is that it is interesting that Article 60 uses the wording may, which seems to indicate that prima facie validity and infringement assessment is not actually automatic. However, until now, in practice, the UPC has systematically assessed prima facie validity and infringement before ruling on a PI application. The second comment relates to the notion of sufficient degree of certainty. And the Court of Appeal in nanostrings versus 10-time genomics has specified that it means that it is at least more likely than not that the patent is valid and infringed. The third condition for PIs being granted is the balance of interest. It results from Article 60, paragraph 2 of the UPCA, but also from the preamble of the UPCA, which provide that in a general way, the UPC ensures a fair balance between the interests of right holders and other parties, and takes into account the need for proportionality and flexibility. This condition is the sole one shared by all the legal system compared within this table. And it is maybe the most important one, considering of the importance to find the right balance until a decision on the merits will be handed down. Based on the balance of interest, the UPC can dismiss an application for PIs, but also limit its scope. In this respect, the Düsseldorf local division has specified in Valeo versus Magna that restrictions must be limited to the minimum necessary to take sufficient account of the alleged infringer's interest. In this case, the court has considered that because for technical and regulatory reasons, the allegedly infringing components could not be easily replaced, A global injunction will have forced BMV, to which the defendant provides this component to cease the production of all the vehicle uses Magna's technology. The courts concluded that a global injunction would have had excessive consequences for the alleged infringer and its clients, and therefore ordered a tailored injunction so that Magna could still fulfill their current obligations to BMV. The fourth and last conditions is urgency, which, as you see from the slide, is not a condition for PI being granted by French courts. Pursuant to this condition, the applicant is expected to be diligent in seeking a remedy against the alleged infringer and sought to bring an application for PIs within a reasonable delay from the moment the infringement began or from the time the applicant became aware of it. It is only 19 months from that the UPC opened, but it is fair to say that the concept of reasonable delay has already been subject to very interesting decisions. In Orthovox versus Mammoth Sports, the Düsseldorf local division has ruled that 1 month from the commencement of the infringement is reasonable. On the opposite, in Ericsson versus Asustec, the Lisbon local division has ruled that waiting 8 months from the commencement of the alleged infringement to lodge an application for preliminary injunctions is not diligent and therefore does not satisfy the condition of urgency. Between 1 and 8 months, the situation is still a bit unclear. Waiting 2 and 3 months from the commencement of infringement to file a PI application has been considered as reasonable, but each time there were very specific circumstances. For example, in the handheld products versus Candid case, the Munich local division took into account the fact that the patent was not published when the infringement commenced, and therefore did not have unitary effect at this time. Similarly, in Valeo versus Magna, the Düsseldorf local division took into consideration that a product need to be ordered and tested before a PI application could eventually be filed. As of today, it is fair to say that what delay longer than 1 month would be considered as reasonable without specific circumstances remain to be seen. Therefore, it can only be advised, if PIs are wanted, to wait as little as possible before lodging an application. Now, I would like to provide you with some stats and some teachings based on them. The main information here is that 56% of the application for preliminary injunctions lodged before the UPC have been granted. This makes the UPC quite patent-friendly when compared to national courts. For example, over the last 10 years in France, only 45% of PI application filed have been granted. In the UK, it's a bit better with 45%, and Germany gets 50%. But in Germany, PIs are generally applied when the patent has already been considered valid on the merits or during an opposition, which considerably limits the number of PI application filed. The other aspect of this stat is that 44% of PI applications are dismissed. And when looking at the reason for that, it appears that lack of urgency or balance of interest are the first ground of dismissal, with 5 decisions representing 45% of the decision dismissing a PI application. Prima facie validity comes second, with 4 decisions representing 36% of the decision dismissing a PI application. The first teaching, based on these figures, is that if you have a strong patent, starting your UPC action with a PI application should be very seriously considered. Because if, like national courts, the UPC happens to massively confirm on the merits its decision ruling on a prima facie validity infringement, obtaining PIs will be an effective way of gaining a position of strength very fast. At this stage, no decision on the merits has never been handed down in a case where PIs had been granted. But it seems reasonable to say that we expect the UPC to rule like the national courts in this respect. For the same reason, a decision dismissing a PI can bury a case on the merits. So it will be wise not to apply for a PI with a patent which validity and infringement is not very strong. In any case, one considering requesting a PI should take a decision with no delay in order to satisfy with the condition of urgency. The second teaching is that defending against a PI application by claiming that the patent lacks inventive step is a bad idea. Indeed, when a counterclaim for revocation is lodged in an infringement action, lack of inventive step is the main ground of revocation, because when the counterclaim for revocation succeeds, the patent is revoked for obviousness in about 60% of the time. However, at this stage, no PI application has yet been dismissed for lack of inventive steps. Does it mean that prima facie invalidity cannot be proved based on lack of inventive steps? Honestly, we do not know that for sure yet. But when defending for a PI application, it is highly recommendable not to ground defense on obviousness, but to prefer either other ground of invalidity, or maybe more importantly, arguing the lack of urgency and the lack of balance of interest as much as possible.
So there are a few bits about preliminary injunctions which might not be core. These have been covered by Alexi and Celine, but nevertheless, there's some miscellaneous points I think worth highlighting. The first is security, which is available just in case the preliminary injunctions transpire to be wrongly decided. Now, of course, these are summary processes, and the courts can't actually assess the validity and infringement fully. And so there's every possibility that the injunctions transpired to have been wrong. And if that had occurred, then the defendants would have incurred loss, and security is there to ensure that they can recover for those losses. I also think that that ensures that the claimants are serious about making an application for a preliminary injunction, because it means that they'll have to stamp up the cash, the significant security, in case in the event the injunction was not justified after all. The availability of security is generally a matter of course if the preliminary injunction is given on an ex parte basis. It does happen. Celine says it's rare, but it does happen. But even so, there are circumstances where you might be able to argue that security shouldn't be granted. So really, before the UPC, things are decided very much on a case-by-case basis. The level of security is also important, although I think the UPC decisions aren't very detailed about how the level of security has been calculated. And I think that is contrasting to the UK, where every single decision is really very well reasoned and justified. But it does seem to be that the level of security is pegged to the stake, amount in stake. And if the defendant isn't represented, i.e. it's on an ex parte basis, they can always make an application to court to up that security at a later date. So as I was saying, security is given on a case-by-case basis, and a really good example, I think, of how the court balances the interests of the parties, I think, can be gleaned from the case of Valeo and Magna, briefly mentioned by Alexi earlier. In that case, Magna, a car parts manufacturer, was alleged to be selling infringing gearboxes to BMW. Now, of course, these cars are very expensive items, and if those gearboxes were restrained from being in use or being in supply, then BMW wouldn't have a car to sell. very difficult for car companies to change gearboxes because these would have had to have gone through some long and arduous sort of regulatory clearance. And so what Magna said was that the level of security required to cover their losses would be in the region of €2 billion. Now, unsurprisingly, Valeo couldn't afford to provide, security of that level. And so what the court said was, okay, Valeo's patent is most likely valid and infringed, and its monopoly needs to be protected. The defendants has also its own interest to make sure that it could recover for its losses. And so what the court did was to allow Magna to fulfill its orders on the books, and then instead reduce the security down from €2 billion to €500,000. So it's really about trying to balance the interests of both parties. And of course, I'm sure Magna would request Valeo to institute the main action to decide whether indeed the patent was valid and infringed. Some other interesting points that have emerged in the past 18 months. There's been a case where the defendant was requested to confine its defence to 3 best arguments, just because, preliminary injunctions are summary procedures. And this decision has been highly criticised because preliminary injunctions could really present serious disruption to a defendant's business. It could actually cost the defendant's business. And so many people feel that the defendants ought to have been able to make a full case against the preliminary injunction applications. And I think the last point would be an interesting one to also highlight. Of costs, yes, costs. You can get costs for failed. You can get your costs back if the claimants fail to obtain a preliminary injunction, and also the claimants can get its costs back potentially if it is successful. PIs and SASI, preliminary injunction and SASI, this is quite interesting because it's possible to do both. So there's been a case where a claimant seized some goods from a defendant, quickly checked whether there's been an infringement, showed the court that there has been an infringement, and promptly asked for a preliminary injunction, which the court granted. So preliminary injunctions can be done in sequence with a SASI as well.
Thank you, Seiko. To finish, I would like to give you a few words regarding protective letters and how to properly use them before the UPC. For those who are not familiar with it, protective letters are like pleadings, possibly supported by evidence, filed before the commencement of proceedings by a person considering it likely that an application for PIs may be lodged. They can challenge infringement arguments expected to be relied on by the presumed applicant and assert invalidity arguments of the patent. Once filed, protective letters cannot be seen on the CMS before an application for PI is filed. However, once such application based on the patent identified within the protective letter is lodged, the letter is forwarded to the panel and to the applicant for PIs. Some strategic consideration. The pros of protective letters are quite evident. They are easily filed and may be a good way to prevent ex parte PIs. Regarding the cons, the main mistake from our view will be to abuse protective letters. Indeed, it is to keep in mind that protective letters are not a firewall against ex parte PIs. For example, in the case Stormer versus Revolt Cycling, the Düsseldorf local division has ordered ex parte PIs while a protective letter had been filed. Even worse, in Orthovox versus Mammut, the Düsseldorf local division has granted PIs without hearing the defendant, considering that its arguments were known from its response to the cease and desist letter sent by the claimant, and that these arguments were not convincing. In this case, the invalidity and non-infringement arguments were not within a protective letter, but it is likely that the court would have ruled exactly the same way based on a protective letter. The conclusion of that is that protective letters should only be filed where strong arguments can be opposed, because if not, protective letters is likely to just burn arguments that, if properly presented on the merits, could have worked. This was our last piece of advice regarding injunctions. We thank you all for your attention and invite you to contact us if you have any question.
Hello, everybody, and thank you for joining us on this session looking at obtaining evidence for use in UPC actions. And in particular, what we're looking at here is a really powerful pre-action measure that's available to you called a seizure order or a saisie order. Those of you who are from France, Belgium, or Italy will be already familiar with this concept, but for the rest of us, this is a new and powerful, or if you're defendant, extremely worrying development. I'm joined today by some excellent speakers from our global intellectual property team. But just first, I'm Alex Brody. I'm a patent litigation partner. I'm based in our London office, and I also co-chair our global tech sector. Michael.
Hi, everyone. I'm Michael Carter. I'm a partner based in our Birmingham office and also head up our automotive IP offering in the UK.
And Mathilde.
Hi everyone, I'm Mathilde Ramon. I'm a UPC representative and I'm a senior associate in the Paris office. I'm a patent litigator and a UPC litigator as well.
Thank you so much. So without further ado, Michael, over to you.
Thanks, Alex. So I wanted to start with looking at why the means to obtain evidence, and seizures in particular, are so important in the context of UPC proceedings. Firstly, as Alex mentioned, there's a considerable shock value involved against defendants in the seizure order in particular. But also, evidence measures are procedurally important in ensuring that the case is in the right shape and proceeds in a timely fashion. Many of you who are familiar with common law jurisdictions will be aware that there is usually a clear distinction between the pleadings or facts relied on and the evidence needed to prove those facts, which will come later via disclosure, witness statements, or experiments and the like. But in the UPC, the case must be fully articulated by providing the evidence relied on where available at an early stage. The procedure is very front-loaded, and as you would expect, the burden of proof is on the claimant. This means that both the arguments and the evidence should ideally be set out as fully as possible when filing the case. And front-loading of evidence makes sense in the context of the timelines that the UPC is holding itself to, where the goal is for a determination within 12 months. As a result, the procedure encourages and indeed envisages parties having evidence filed early, and there are limited opportunities to amend or supplement later. Now, there are a number of ways to obtain further evidence to substantiate your claim during the proceedings, and these are set out in the agreement and the rules. But today we're going to focus primarily on seizures because that tends to be the most common and one of the most shocking approaches that can be taken. Now, two important preliminary points. Firstly, when we're talking about seizure, we're not just talking about seizure of physical materials. It also covers computer records and allows the questioning of individuals. Secondly, it's available before and during proceedings, and it's available on both an inter partes and an ex parte basis. Although, as we'll see for understandable reasons, it's most common for it to be deployed ex parte. Handing over to Mathilde, who will discuss some of the specifics.
Thank you, Michael. So SESI is a very powerful tool, and if we look more closely at the way SESI has been used so far, we should look at some figures first. So far, the UPC ordered 11 SESI. Most of them were ordered by local divisions based in countries which already know SESI, meaning France, Italy, and Belgium. But interestingly, some local divisions based outside of those countries in Germany, Denmark, and the Nordic Baltic division also ordered SESI, although those countries do not know SESI in domestic law. 2 orders for inspection have also been granted. As a reminder, order for inspection and order to preserve evidence are different in the way that for inspection, you just go to the premises, but you don't take anything. You just have a report which is drawn up, while for the order to preserve evidence, the SESI, you actually gather evidence, you collect it, and you can take it with you. So all those SESI and in orders for inspection have been ordered before any proceedings. So the venue was based on where the infringement was actually taking place in application of the rule of jurisdiction between the various local divisions. How does it work in practice? Well, the applicant will actually file an application requesting the SESI with reasonably available evidence showing that its patent has been infringed or is being infringed or is about to be infringed. In this application, the measures requested will also be set, as well as the location where the expert should go to conduct the SESI. If the principle is inter partes, as mentioned by Michael, the applicant can request it to be ordered on an ex parte basis, meaning that the defendant won't be heard by the division. It's more powerful because there is a surprise effect because you go unannounced there. So if we look at figures again, 9 SESI were ordered ex parte out of those 11 SESI ordered. To order the SESI ex parte, the court will look at the emergency, of course, as well as the risk of destruction of the evidence or the risk the access won't be possible afterwards, and will outweigh that with the interest of the seized party. So if we look at some strategic use cases, many SESI, and most of them were actually ordered to be performed on trade fairs. A very interesting case is the ortho apnea case here, where the defendant is based in Spain. If he would have stayed in Spain, his life would have been easier because basically there was no valid patent in Spain. He goes to this trade fair in Belgium. Too bad there is a patent which is valid in Belgium, and there is a SESI in Belgium against him, and it's ordered ex parte, so the bailiff just shows up and he cannot do anything. A very interesting one as well is the fact that, and it illustrates the fact that the UPC is very reactive on trade shows, SESI, because on the data detection case, the order was handed down on the exact same day the application was filed, and the SESI took place the day after, which was the final day of the fair. So it's very interesting because it shows that one is never safe first, and that the UPC is extremely reactive when it comes to SESI. Other examples of where SESI can take place, it can take place in premises, so it can be the infringers, the suppliers, the clients, and in those cases, it can happen simultaneously as well in 2 different locations or even more. Interestingly, the evidence submitted to show that the patent was infringed were coming from outside UPC territories. So you have to be very mindful of what you are doing worldwide, because all the elements that you publish or that you use worldwide can be used against you as an evidence to request a SESI by a patentee. So in view of this example, as an applicant, there are some practical steps that you can take, and Alex is going to present those steps to you.
Thanks, Mathilde. So if you're an applicant, you're a patentee, and you want to take full advantage of this fairly startling measure, what do you need to do? Well, as Mathilde alluded to, you need to put your case in absolute detail before the court. So you need to be identifying what you want to go and get. You need to identify who is going to be part of that team. So if you want your external lawyers to be part of that team, you need to have asked for them. You also need to provide this information on a full and frank basis, which means that not only do you have to explain for your own purposes why this is so urgent, so necessary, but you also need to tell the court all the arguments that the other side would put had they been given the opportunity to come before the court. Now, obviously, if you're going into parties, that won't be necessary, but typically this is going to be an ex parte application. So you need to be telling the court what the other side would want the court to have heard. You're also potentially going to have to provide security. That's going to compensate your target if you cause any damage during the seizure or if the order is later overturned. An important point to note is that the clock is ticking to commence proceedings. So when you apply for this and it's granted, if you execute it, you are then on a deadline to issue your main proceedings. So I think you need to be, as the phrase goes, all in on suing somebody before you start asking for these orders. And then lastly, or that's point one, is choice of expert. The court will appoint the expert. The court has a list of experts now who will go and commit the seizure for you. But obviously, they're not going to have an expert in absolutely every technical field, and you might have some very clear ideas on who the best people are. So there's nothing to stop you suggesting a list of names to the court when you make your application in order to be helpful, but you should know that you don't get to choose. So, Michael, if I manage to get this order and I'm coming towards your trade show or your premises, how are you going to stop me?
Well, subject to one possibility that I'll touch upon at the end, I don't think that I can. And also, as a defendant, I don't have the luxury of time. But what I can do is I can take practical, proactive steps to ensure that I can make a quick and effective response to any order that may be made. And the key component of this is a policy and process document that can be referred to in the event of a seizure being effected. This document's likely to be similar to the sort of dawn raid policy document for competition raids that you may already have within your businesses. And we've got experience of putting these in place for clients, giving training to reinforce them, and carrying out mock dawn raids to check the resilience of these policies. That's something which should be done for the UPC as well. Now, what should go into that document? Well, firstly, it should set out what to do in the event of a seizure being effected. It should describe the process and responsibilities and do's and don'ts. For example, it should recognise that you cannot stop the court-appointed expert coming in and from conducting the seizure, but it should ensure that the order is checked and that only the relevant people are in accordance with the order are in attendance. It should provide guidance to allow those on the front line of your business to deal with the order calmly and ensure that they don't panic. For example, does your receptionist know to show the team to a waiting room to give you time to call your lawyers? Secondly, and really importantly, whose responsibility is it to call the lawyers, and do they know their details? And who else within the business needs to be informed? And thirdly, it should set out guidance for how to monitor whether the order has been effected properly. The defendant has an opportunity to challenge the validity of the order, particularly where it's been ordered on an ex parte basis. Now, this policy and process document will need to cover a range of different situations. For example, the process at a trade show will be different to the seizure at a factory. But in both cases, it should teach how to minimise the disruption and ensure that you and your employees appear cooperative without providing undue assistance. The policy document should then be supported by training of relevant personnel. This will make sure your staff are aware of how to act when a seizure is taking place and how to respond, importantly, to any questions they are asked. Perhaps similar in a way to deposition prep that some of our US colleagues will be aware of. Thirdly, confidentiality is key. Making sure that documents have been marked according to confidentiality or trade secret policies is important because it is possible to keep confidential information out of the hands of the applicant itself. But that is much easier to do if the relevant markings have been applied in accordance with your policies in the first place. Finally, I mentioned at the outset that there was no way of stopping a saisie, but this is subject to one point, and it's filing a protective letter. Now, there's no guarantee that a protective letter will be successful, but it can be an efficient way of ensuring that the arguments that you may want to make are properly considered by the court on any ex parte application for provisional measures. Now I'm going to hand over to Mathilde.
Thank you, Michael. So we said that there is no disclosure before the UPC. This means that apart from seizure, there are other limited means available for evidence to be gathered or to be available. For instance, there is the request to produce documents, and there is the right for information, which relates to supply chain information, financial and accounting information. We already have several examples where those provisions have been used before the UPC, but the most important point to have in mind when using them is the timing, because those tools are used during proceedings rather than before commencing proceedings. And we have seen a progressive switch regarding the right for information, which is now used before the decision on the merit is even handed down. This enables to speed up the proceedings when you are a claimant, because you will have you will be able to accelerate the request to determine damages. UPC proceedings work a bit like UK proceedings. It means that there is a first decision on infringement and a second decision on the determination of damages. This is not that important for defendant, but what is important for defendant regarding timing is the fact that during proceedings, you can request documents to be produced, which would show that the claimant is actually lacking standing. It has been used in some cases, and it's really interesting for the defendant because in one request, basically the entire proceeding could appear to be completely inadmissible. In a very interesting example, it was used during the proceedings by the claimant itself, who was trying to circumvent a confidentiality duty which was set in some licensing agreements. So in this example, Panasonic was actually trying to get a judicial decision because it was the only way for Panasonic to actually be able to produce evidence which was showing that it had offered to Xiaomi friend conditions in its licensing agreements. So basically what Panasonic did is that it went to its licensees requesting to be authorized to produce those licensing documents. The licensees refused, and Panasonic had no other choice to go to the court asking to be ordered to produce. So nothing could be actually reproached to Panasonic. The court considered it was proportionate and justified, so Panasonic was ordered to produce those licensing agreements. The only thing is that Panasonic had to redact those documents because it could only rely on the data which were not redacted. Confidentiality, as we see, is also a big issue in those situations. The UPC is generally very mindful of that. That's why it provides for redaction of some documents, but the ordered party can still file a separate request for the access to document to be even more restricted. And precision regarding the data to be requested is also key, because the broader you are when you request some information, the more risk you have not to obtain it, because it would be considered not proportionate by the court. So although those tools are less powerful than a CSE, they are very convenient to obtain either additional information, either when you are a defendant because you could be in a situation where you don't have any other choice than using those tools. But there are also other limited means available, and Alex is going to discuss them. Alex, over to you.
Thanks, Mathilde. So other possible evidence gathering means, but this is all post-commencement of proceedings, so you've already committed here. So you can adduce witness or expert statements as you'd expect. You can ask the court to order experiments, and the court itself can appoint experts. But as Mathilde said, this is all very limited. And in particular, you've got to realise that once you've pressed go, the court is trying to get you to a trial date within 12 months. So the amount of time you've got for assessing the case in front of you, making applications and getting extra orders, and then actually producing evidence or producing experiments, it's extremely tight. Now, the rules of procedure do allow for cross-examination of experts at trial. It's generally considered unlikely, and it has been very, very rare to date because the trial is only going to last a maximum of 2 to 3 days. So you don't have a great deal of time. But last week, in the Abbott and Dexcom case, all 4 experts were fully cross-examined at trial. And the UPC court noted that this had been an extremely helpful exercise. So whether this norm of lack of cross-examination is going to continue is currently got a great big question mark next to it. So thank you so much for listening to us on this.
Hello, welcome to the Gowling webinar on UPC preparation as a defendant. My name is Marianne Schaffner. I'm a UPC representative based in Paris, having experience in litigating in different jurisdictions in Europe, France, Belgium, Netherlands, Germany, and Italy.
Hi, Marianne. I'm Alex Driver, and I'm a principal associate in the IP team. I have experience of working before the High Courts, Court of Appeal in the UK, and also on UPC matters. You'll see from the slides, everyone, that Hugh Evans was originally involved in the live recording. Unfortunately, he's not available today, but hopefully Marianne and I can cover off the points that were addressed in this recording. We wanted to jump straight into some of the key takeaways from this session, which, as you know, is preparations in the UPC as a defendant. And the timeframes are really one of the key points. So as everyone knows, UPC proceedings are quick, with the expectation being that judgment will be reached within about 6 weeks following a 12-month period of preparations before the oral hearing. So preparing a defence on non-infringement and invalidity as early as possible will be instrumental to success, we'd say. And ideally, that would start to happen before action is even commenced. But you also have to be aware of other tools that patent proprietors might use in the UPC. So, for example, SAYZs. And we'll discuss today how you can get prepared for a possible SAYZ being made against you. And preliminary measures as well, other preliminary measures. So particularly here, we're thinking of protective letters and how they can be best deployed in the UPC. And Marianne, there was an additional point as well, which you've mentioned to me about the EPO's watch service, which seemed interesting.
Yeah, actually, it's important to watch the patent of your competitors, to look at whether the patents, if it's patent applications, whether it's been granted with a unitary effect, because obviously if there is a unitary effect, the patent is going to be subject to the exclusive jurisdiction of the UPC. As well, it's important to have a look at the CMS of the UPC in the case an opt-out has been filed. And as you will describe, Alex, later on, when there is an opt-out which has been filed, the validity can be challenged. And this is what we are going to cover later on. Thank you.
Thanks. We wanted to start with a scenario, and it will be one that is familiar to most. Most people will have also seen color-coded maps of Europe when they're having any sort of UPC webinar or presentation or discussion. So the scenario we'll look at is set out here. We've got Actor X manufacturing in France and selling across various countries in Europe, including other UPC countries like Germany and Italy. Competitor Y was recently granted a European patent validated in all of those countries. And we've here envisaged two scenarios. Either it has opted out or it hasn't opted out of the jurisdiction of the UPC. So it's a fairly simple scenario. The question is, what can or should Actor X be doing to mitigate the risk of an injunction in its key territories? Marianne will take us through some of the options, but if we've missed anything, then I'm sure somebody will let us know by email.
What might Actor X do? Obviously, there are several options available to Actor X. First of all, there is the option of filing an opposition provided that the patent has been granted in less 9 months. So to file the opposition. You can as well, if the 9 months have lapsed, actually start either a national revocation if the patent has been opted out, or you can also file before national court a DNI, a declaration of non-infringement. If the patent has not been opted out, actually, you can start actually a UPC case of it either before the national court, but as well before the UPC. And this will allow you to get a revocation of the patent for the entire countries where the patent has been validated. So with the EPE opposition, you will have 39 countries covered by the revocation, while with the UPC, you will cover the patents where they have been validated. It's important before deciding on whether you are going to start a national or a UPC case is to check the opt-outs, and Alex is going to cover that. It's not because a patent has been opted out that necessarily actually the UPC will not have jurisdiction over any action. You should be prepared for CZ if you are under some threats, and I will cover that. Or you can file protective letter, and I will cover that just after. And actually, we wanted to know how many people have filed a protective letter, and they are a very limited number, while it's important, as you will see. And in any case, actually, given the timing is very short, you have to prepare your technical arguments anyway on validity and infringement. So the protective letters, what are the protective letters? What is a protective letter? Actually, a protective letter is a brief that is filed at the registry of the UPC. It is provided by Rule 207 of the Rules of Procedure of the UPC. And the protective letter aims to provide the UPC with invalidity and non-infringement arguments, as well as evidence before any ex parte measure be requested by the patentee. It is really a preemptive defense, which ensures that the court will consider your argument as a defendant before granting a preliminary injunction, should it be actually seized by an ex parte application. So it is very important actually to mention that the protective letter is confidential. The patent holder is not aware of the existence of this protective letter until an application of preliminary injunction is filed, and the court will put actually the protective letter on the table. Next slide, please. What is important to know is that it's not because you will have filed your protective letter with invalidity arguments and non-infringement arguments that in the end you will be completely protected and that no injunction shall be granted. Okay, it's not completely bulletproof. The UPC retains discretion on whether or not it would grant the ex parte measure in light of the application, the protective letter. The UPC will decide on whether or not it will hear the defendant, and if there is an application on an ex parte basis. So, and this is what has been decided by the local division of Düsseldorf in a decision in Maistromer versus Revolts of Cycling in June 2023, where actually the local division has noted that the defendant has not filed any invalidity arguments in the protective letter. So meaning that it was an indication for the court that maybe the patent was strong and had no weaknesses pointed out at least by the defendant, and in the end held that the non-infringement argument was not convincing and granted the injunction. So it's important really to work on your protective letter and not to forget that actually invalidity arguments be present, because it can be taken in account by the court in the end. Next slide, please. At the same time, you can say, okay, well, I'm going to file a protective letter. At the same time, actually, it's interesting to note that the local division, again, of Düsseldorf, in a decision of last December, has criticized a defendant which had received cease and desist letter, so who was aware of the risk of an action. The court said, okay, you should have filed a protective letter, and failing doing that, actually, it means that the preliminary injunction should be granted because there was no arguments to put on the table by the defendant. So here, really, the court say, okay, you have missed the opportunity to strengthen your defense in response to what the patentee was alleging. So that's why, next slide, please, it's important to file the protective letter. Because actually, okay, as I said, it doesn't guarantee that actually you will have an inter partes hearing, that you are going to be heard as a defendant. It is not either 100% PI proof. However, it gives you the opportunity to present your arguments. If you don't do so, and that you actually the patentee can prove that you are under threat, it can be criticized and pointed out by the UPC. And if in the end there is no PI which is applied on ex parte basis, but it's applied on inter partes basis, you will have safe time because you will have all your arguments. And if ever there is only an action on the merits, again, you will have all your arguments on validity and infringement ready, because as we would say, it's very short. You have only 3 months to prepare your defense on the merits. So that's what I wanted to say about the protective letter.
Thanks very much, Marianne. It's clear from that discussion that the protective letter is a key defensive tool in the UPC. Another one is the ability to request access to opt-outs. There's been a lot of talk about the public availability of documents on the CMS registry, such as pleadings, but the registry also hosts other documents which might be interested in one of the scenarios we've seen. So that's where a defendant is concerned about a potential patent infringement suit being brought against them and an opt-out has been filed. So the question is whether that opt-out has been validly or invalidly filed. And particularly this relates to Article 10 of the UPC agreement and Rule 37.1 of the rules governing the registry, not to be confused with the rules of procedure. Those rules allow any UPC representative to access documents relating to an opt-out and therefore checking its validity. A wrongly filed opt-out, for example, in the name of the wrong proprietor, could mean that the possibility of filing a revocation action or DNI action is opened up before the UPC. Importantly, it is for opponents to test the validity of an opt-out because the registry does not check as a matter of course. That's not surprising. That's not unsurprising, given there have been well over 500,000 opt-outs of European patents, and it's inevitable that there have been some issues. For example, in Toyota Motor Europe and Neo Wireless, a Neo USA entity had assigned the German designation of its EP to one of its German subsidiaries. The opt-out was filed by that Neo USA entity and not by the German subsidiary. So the Court of Appeal decided that the opt-out wasn't valid. In other words, you have to have all the relevant proprietors file the opt-out. So why does it matter that the potential infringer could start proceedings before being sued themselves? Well, timing may be important. For example, if there's a parallel EPO opposition and you don't want to stay of the UPC proceedings pending the result of that opposition, but also it means that the case will end up in one of the central division seats specialised in hearing revocation actions in the relevant technology, and that may be considered to be a benefit. Now I'll pass on to Marianne, who will talk about SASEs.
Thank you, Alex. So SASE, as a defendant, when you are aware that there is a risk of an action because you've received a cease and desist letter, or because you are about to launch a product, there is another risk as a defendant, is the SASE. Next slide, please. What is the SASE? The SASE actually is a way of collecting evidence at the premises of someone who can detain evidence of infringement. And this means that the patentee or the patent holder or the exclusive license can obtain from the court the right to access to premises and collect evidence. And this means, what is evidence? You can collect actually just a description of a process or just a description of a product. You can have physical seizure of products, and you can have to communicate some relevant documents, and that is to say, okay, financial documents, but as well any kind of books, plans, and so on, describing actually the product really in relation to the infringement. And the objective is really to determine on whether or not the patent is infringed. Before the UPC, actually, the court will appoint an expert who is often a patent attorney, an independent patent attorney from the applicant for the seizure. He will be assisted by a bailiff who will enforce actually the decision. There is no possibility to oppose to the performance of the SASE, but there are some actually actions that can be taken. And especially you have to keep in mind that the seizure can be granted on ex parte basis when there is urgency. So for instance, there is a trade fair that actually there are only a few days where the product is going to be exposed, irreparable harm, or there is a risk of evidence being destroyed. So what can you do, Alex, as a defendant?
It's not possible to foreshadow the grant of a SASE, so there's no equivalent to the protective letter. But it's really important to have everyone ready for a SASE. And I think probably it's important here to stress the small details. So, for example, if you think you may be subject to a SASE, you need a welcome protocol. What happens when those bailiffs enter the door, or even before they've entered the door at the security gate? So are those security gate members, are they trained? Do they know what they're supposed to do, who they're supposed to ring? And then are they supposed to send the people on to reception, or should they be held back at the security gate? Now, ultimately, those bailiffs probably will end up at the receptionist at some point, and so those individuals also need to understand what their role is, who they need to call, and what's going to happen next, and really take control of the situation. Another key step would be ensuring that the relevant in-house and external counsel are contacted urgently, and there should be a protocol for who is contacted and in what order, and an understanding of how quickly they can get to the premises. There may be questions around tactics which could be used. So, for example, should the bailiff be kept at reception because they might get slightly frustrated, and particularly you might not want them sort of standing in an open area, or should they be taken to a separate room to allow them to have a space, perhaps presented with a tea or coffee or something like that? I think one important thing that really does need to be emphasized, and Marianne, you've mentioned this to me previously, is to identify one person who's in charge of all communications with the applicant of the SASE, and potentially even have those recorded in writing. And I think, Marianne, you've also made it clear to me that one person might need to have a backup person in case they get drawn into a particular area but really ensuring that there's a chain of command and everybody understands what their role is in that situation, if that should happen. I think we'll just move on to some separate points around timing now.
Thank you, Alex. Yes, timing. As you may know, before the UPC, everything is about time. Actually, the UPC rules introduce a front-loaded procedural system. Okay, what does it mean? It means that the parties have to elaborate their arguments and evidence in concrete terms with their first statement of claim or of defense. So as a defendant, actually, you have to move very quickly. You receive the complaint, the statement of claim. As soon as you have accepted the service of the statement of claim, then the clock starts running. First of all, there is 1 month, but for you, if you want to find some preliminary objection about the jurisdiction of the court, the jurisdiction of the local division, because you can challenge the venue where the case has been filed. So everything has to be done in 1 month, okay? But then you have 3 months from the acceptance of the service of the statement of claim to prepare and file your statement of defense, which will comprise infringement defense and as well invalidity defense. Even though we've seen that before the German court, divisions, often no invalidity arguments are filed, but in the end it may have an impact on infringement. So then you can, there is the question of whether or not you can request for bifurcation. So the request for bifurcation, if you want that the validity be heard before and by the central division, rather than by the local division before which the action for infringement has been filed, there is this possibility to file the request for bifurcation. For the moment, it has not been very successful because the request for bifurcation, there is no request for bifurcation which has been granted yet. So then you have to assess the value of the claim, assess the value of the claim to determine what's going to be the fees. If you can enjoy the discount fee as SME, you have to prepare all documents that will prove that you can actually enjoy from the discounted court fees. And obviously, you have to look, as we said just before, any case is whether or not the opt-out has been filed properly and is valid. You have really to watch the patent of your competitors, because you can notice that one of your competitors is going to withdraw the opt-out, which means that if there is a withdrawal of an opt-out, there is a high risk that a case before the UPC starts. You have to think about the translation of all the documents and to have everything in the language of the procedure. Being recalled that most of the cases now are run in English. And then, okay, there is if you are a claimant, there is a question on whether or not a fund is going to invest actually in your litigation. And as a patentee in advance, actually you have to actually think about the insurance and find a fund as well. There is something else actually which you have to think about, and I would say before any case has started, is to have your best law firm who is going to be ready to assist you as soon as you receive a statement of claim, given this very short timing. So you should not receive the statement of claim and start thinking about who I'm gonna hire. So you are, what's going on? Stop. Stop. There is an echo.
Marianne, just on. Oh, you're on mute now.
For you to be ready in case there is a case to have your counsel selected. Alex, what's your recommendation?
Absolutely, that's clearly of importance. And one thing you and I have discussed, Marianne, before is potentially even having 2 sets of counsel ready, because if, for example, there's a conflict issue that arises having another person who you can call who's already familiar with the technology, potentially the patents, could save a number of weeks or even months, because as we know, sometimes those issues can roll on over a long period. And the final point we have there is really just in relation to PIs, when all of this can happen really, really quickly. PIs can be obtained very quickly, and as we know that the UPC is willing and does need to look at the validity and infringement in a PI situation. So that technical analysis could have to be done within days if it hasn't been done in preparation. And that takes us to the end of our session. Of course, we welcome many questions by email. Do let us know if there's anything that's arisen in the course of this discussion, or just if you have any other general questions about the UPC, we'd be pleased to advise. Thank you very much.
Thank you.
I was just going to pick up some points on our session, Marianne, which came out, which is how to be ready if you have a case against you. And the main things that we picked up on was really is this. Well, the problem is, as a defendant, you've got to be able to react very quickly. So to the extent you can plan ahead. To the extent you don't really know where the threat's coming along, make sure you've got what you think might be your defense team in place as early as possible. And that may be sort of reserving some law firms ready for yourselves, because you don't want to get tied up in conflicts. Of course, it's not just about the speed of providing your defense. You've also got to think about things like SAISs and how you would be ready for those. You might want to think about finding protective letters. And we had a good discussion on that. And we also said, of course, we've been focusing here on if you are the potential defendant to an infringement action. It also works out as well if you are actually the defendant to a potential revocation action as well. So, think about what you need to be doing to be ready for that. So it is, to the extent you can prepare, you should prepare more so than what you're probably used to in normal national actions. So I think, Alex, I think in your session you were going to pick up a few points that came out of yours. That's Alex.
Yes.
Yeah.
So I was fortunate enough to get the really interesting one, which is on CESEs with Michael and Mathilde. And I think where we got to on that is, if you're a claimant, why on earth wouldn't you? Because you can cause maximum havoc, great pressure, and hopefully get some useful information, but you're going to fast track your way towards the negotiation. And if you are defendant, it became really apparent, and Mathilde and Michael gave some really useful how-tos and practical steps on this, about get yourself ready, train your people, have a policy, make sure everyone knows what they're doing, make sure they know not to slam the door in the face of the expert, but to quietly usher them into a waiting room where they can cool their heels whilst you read the order and phone your lawyers. And have also just put your people on their toes in terms of some dawn raids, and warning everybody when they pitch up at a trade show that this could happen to them, and how to move everybody off the very public trade show stand to a quiet corner to then deal with it, to make sure your reputation is kept intact. So Mathilde and Michael had some really useful practical tips there, but that was it. It's like, why on earth wouldn't you, and get ready.
Yeah, I think I'll add there actually is one thing I've observed by reading a few UPC decisions is that the UPC is quite good at looking at the facts and trying to sort of preserve everyone's interests. And where you've got a seizure of a stand in a trade show, the order actually says it needs to be done before the doors open to the public. So there are these measures that the defendant can ask for so that minimal disruption is made, and you can sort of try and preserve your reputation as far as possible. So there are lots of practical considerations that you might put forward to the court, and if they think it's a good thing to do, they would order that.
Thanks, Seiko.
And Celine, I think it was your.
Yes, very briefly, because I think that we are going to run out of time. Yes, on preliminary injunction. So we discussed, of course, the very strategic, I would say, mean that it represents, because yes, it's a very big impact if you are granted a preliminary injunction up front, but it can help you, of course, settle the case without having to go until the end of the procedure on the merit. But it can also be very risky if you don't get the injunction. So yes, to be used really carefully, and to be the arguments on which you based it to be chosen very carefully. And we have seen that so far, the UPC mainly ground its decision on urgency rather than validity. So they look at the validity of the patent before issuing the preliminary injunction, but they do not go that deep, like, for example, a French judge would do.
Yeah, and I would also say, actually, for the UPC, which is quite different from the UK way of looking at whether to order a preliminary injunction, which is that for the UK, really it's all about trying to prevent the risk of harm to the claimants that is caused by the infringement. It's all about the harm. So that's why the court in the UK don't really look into the validity and infringement. The UPC perspective is, and actually the continental court's perspective is a little bit different, and they do tend to look into infringement and validity as well. So I think there is sort of like a cultural difference between the court systems.
Okay, I think we're out of time. Obviously, we will go on for a lot more if we did have more time. But I was just going to say thank you to everyone for joining. As Celine and Marianne said at the start, if anyone has any burning questions that they'd like to ask, please just do email them in, contact us or whatever. You probably have our details, and we'd be very happy to answer them as well.
Yes, and as I said, you can find you'll have a link to watch the webinar again, the recorded part. And thank you very much to everyone for joining us today. And we hope to see you all soon for another, I think, other topics on the UPC very soon.